You're driving home, and out of nowhere, a severe stroke hits. By the time you reach the hospital, you are completely unconscious and unable to communicate. While you are lying in that hospital bed, the clock on your life keeps ticking. The mortgage is still due on the first of the month, your utility bills are piling up, and your small business still needs payroll approved. Most people assume their spouse or oldest child can just walk into the local bank branch, explain the medical emergency, and start signing checks to keep the household running. But if your name is the only one on that account, the bank will freeze it entirely. In the eyes of the financial and legal systems, being a loving spouse or a blood relative grants zero legal authority to access your assets. I'm Marcus, and what we just described is called the legal vacuum. It's a dangerous gap in time where urgent financial decisions have to be made, but absolutely no one has the legal right to make them. Today, we are going to walk through the basic legal framework you can use to prepare your household before a crisis forces your hand. Because if you don't proactively assign your legal rights to someone you trust, you surrender those rights to a court system you cannot control. The tool you need to bridge this gap is called a power of attorney. It involves two parties. You are the principal, the person holding the legal rights, and you draft this document to transfer specific legal authority to an agent, the person you trust to act on your behalf. But a standard power of attorney automatically expires the exact moment you become incapacitated. To protect yourself in a medical emergency, you must include a specific clause that makes the document durable. That single, vital legal keyword ensures that your agent's authority remains completely intact, even if you lose your legal capacity. Let's look at what happens if that medical crisis hits and you do not have a durable power of attorney in place. Your family is immediately locked out of your finances. To get legal access, they have to hire lawyers and petition a civil court for a conservatorship or a guardianship. That process requires paying thousands of dollars in legal fees up front just to open the case. Every detail of your physical and financial health becomes a matter of public court record. Ultimately, a judge, a total stranger who doesn't know you or your family dynamics, gets to decide who manages your life and your money. Failing to sign a few pieces of paper right now forces your grieving family into a slow, expensive, and entirely public legal battle later on, just for the right to pay your mortgage. Now, let's look at the exact same medical crisis, but this time you already executed a durable power of attorney and kept it ready. Your agent drives directly to your bank, presents the document, and legally steps into your shoes. They unlock the accounts privately and keep the household running without stepping foot inside a courtroom. Granting another person the legal right to freely withdraw your money and entirely manage your property is a significant risk. If this power is placed in the wrong hands, it can lead to immediate financial loss. The vital safeguard is selecting your agent based strictly on their financial responsibility and calm judgment. You absolutely do not have to pick your oldest child or your closest relative if they are bad with money. You can also write strict boundaries directly into the document. You can grant access to your checking account, but forbid the agent from selling your real estate, or require them to provide a monthly financial ledger to another family member for oversight. You also need to name a successor agent. If your primary choice is traveling, unwell, or simply unwilling to serve when the crisis hits, the successor acts as your mandatory backup. A truly well-crafted legal document balances total protection for your family with strict safety limitations on your agent's actual power. To put this into practice, here is a rapid-fire 7-step execution plan you can follow to get this done. Step 1. Determine the scope. Separate your financial control from your medical directives. Step 2. Select a highly responsible primary agent. Step 3. Choose a backup successor agent. Step 4. Clearly write out any specific limitations or reporting requirements you want to impose on them. Step 5. Execute the document according to your specific state laws. This almost always requires a notary public and impartial witnesses who are not named in the document. Step 6. Distribute official copies immediately. Give them to your agent, your backup, and your primary banks so the paperwork is already on file. Step 7. Review your paperwork every few years and update it immediately following major life events like marriages, divorces, or deaths in the family. A perfect legal document locked inside a heavy safe that no one knows the combination to is completely useless during a 3 a.m. emergency. A durable power of attorney is a practical tool that helps prevent a medical emergency from escalating into a chaotic legal dispute over your finances. State laws vary wildly on how these documents must be drafted and witnessed. You should consult a local estate planning attorney or a legal aid clinic in your jurisdiction to draft your specific paperwork. In our next episode, we'll look at the other side of this timeline, exactly what happens to your debts and assets after you pass away. Subscribe to Know Your Rights USA to continue mastering the documentation required to navigate the legal system. Knowing your rights is the first step, but signing the documents is what actually keeps your finances and your family's future stable.